I lost my whole life, and I have messed up over and over again. I just can't do no more jail time. I just want my life back. I miss my son.
I want to give you a chance, but you don't seem to be taking this seriously.
I do, sir. It was just rough.
You had an opportunity to speak. Now it's my turn. This is case number 25CR42962, the state of Ohio versus Bobby Joe Woods. Ms. Woods is before the court with her counsel, Ms. Hinkle. Ms. Nicholson, on behalf of the state of Ohio, we're here for sentencing. Anything on behalf of the state?
There is no lab reimbursement requested. We will defer to probation's recommendations and what we discussed back in January.
Anything else from probation? Ms. Hinkle?
Thank you, Your Honor. In mitigation, Ms. Woods, she's had a rough time. She did lose her daughter, which did lead to a lot of substance abuse. And so she is really trying to get back on track. She wants to do mental health services. She wants to get back involved with substance use counseling. She was really interested in going back to Sojourners. We've talked about that, and that might eventually be an option. But I do understand that she has a holder out of Kentucky right now, and so I know she wants to get down there to get that handled so she can start to get the treatment that she needs. So I would just ask that you take all of that into consideration.
Ms. Woods, anything you want to tell me?
I want to apologize. When I lost my kid, I lost my whole life, and I have messed up over and over again. But I've been in my cell by myself for over a month now, and I've been a lot of thinking. I finally have breathed, I guess. I just can't do no more jail time. I just want my life back. I miss my son. I'm sorry. I just want my life back, and I will take it back, whether you give me more time or you don't, because I'm done with this life. I'm going to make my son proud of me and her up there. And I'm sorry that I came into your town and made a mess of it.
All right, the court has considered the statements made here today, the purposes and the principles of sentencing, the relevant seriousness and recidivism factors. Ms. Woods, the court recognizes that you have issues in other states that you have to comply with. I know you're not from around here. You're from Indiana, correct?
Yeah, I live in Ohio.
You live in Indiana, yeah. Okay.
But, yeah.
You don't plan on staying in Ohio? All right, at this point in time, what the court's going to do is I'm going to order you to serve 120 days in the Warren County Jail. I'm going to give you credit for the 120 days you've already served.
You are?
Yeah, I'm done.
Thank you so much, Your Honor. Thank you, thank you, thank you.
All right, now let me finish this because there are some other things I have to tell you. You're subject to a discretionary period of post-release control, which means that if you are sent to prison on discharge, which I'm not sending you to prison, but if you were sent to prison, when you are released, the Adult Parole Authority may supervise you for up to 2 years. If you violate that supervision, you can be returned to prison for up to 1/2 of the court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. You do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost, including an attorney. Ms. Nicholson?
You just want that as straight 120 days, no community control in term, just straight.
Yeah, she's going to Kentucky now.
Okay,
so,
sounds good.
We know what Kentucky is.
Yeah. All right. Good luck to you, ma'am.
Thank you so much, sir.
Thank you, Your Honor.
And she's indigent, obviously.
Yep,
Okay.
thank you.
Case number 24CR41909, the state of Ohio versus Deshaun Brinson. Mr. Brinson is before the court with his counsel, Mr. Wendell, Ms. Tranter, on behalf of the state of Ohio.
You can do your
This final probation violation hearing, Mr. Wendell, does your client wish to have a hearing?
Your Honor, we would waive a formal reading, accept the allegations, enter an admission, a plea of guilty.
All right, Mr. Brinson, you understand that you are entitled to have a hearing?
Yes.
You wish to waive that hearing and admit to the violation?
Yes, sir.
All right, the court's going to find that you have violated the terms of your community control. The only thing you want to say?
Your Honor, thank you. Judge, in mitigation, I think when you inquire of Mr. Brinson today, you're going to hear an individual that is upset that he let you down, and perhaps even more importantly, upset that he let himself down and didn't follow your orders. He accepts and acknowledges the wrongfulness of his conduct. I think, while certainly not excusing the behavior, I think when you inquire of him, it'll give some insight into why he did what he did. We would respectfully, and I know he's asked it of you in correspondence, request that he be restored to a period of community control. Judge, he is realistic, however, the severity and significance of his conduct, I know he does wish to address the court.
Mr. Brinson, anything you want to say?
Yes, sir. First, I'm gonna take accountability for my for what I did, but I think it was like I just was moving fast to get out. I was at a great auntie house that I just met when I was 15. So, and she was just basically all about money. So when I went there, you know, I was on house arrest still. I had to finish school, GED, and do the outpatient. So it was just a lot. But with her, she wanted money. Then she got to acting weird when I ain't had the money. Like she'd just make a whole meal and just say some weird stuff like everybody eat before he eat. So, and then my cousin, I was doing good. I got a curfew. I was making it back. My cousin, said she was gonna come get me. The last 30 minutes came. She told me I had to find another way. But by the time I found another way, I was late. So that's when my Miss Fisher took my curfew away. So that day I just got mad and just lost it and just took it off. But the whole period of the time, I was just with my girlfriend in the house, chilling with the kids, just helping. I think if I can get another chance to get probation, I know I'll be all right.
Mr. Brinson, if you recall, when I sentenced you, the prosecutor's office wanted me to send you to prison. Anytime we have a failure to comply, they are always asking that I send people to prison. With you, I saw something in you. I really expected you to be compliant. I gave you that opportunity, but on this type of charge, you don't get a second chance, third chance. So at this time, the court is going to make a finding that you are no longer amenable to community control in the prisons is necessary to fulfill the purposes and principles of sentencing, including punishment, deterrence, and protection of the public. On the failure to comply, the court is going to order you to serve 24 months in prison. The receiving stolen property, I'm going to order you to serve 12 months in prison. The obstructing official business, 12 months in prison. Those to be run concurrent with each other, but by law they must be served consecutive to the failure to comply. You have 121 days jail time credit at this time. The court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions, but there is still restitution owed of $700 to Maria Gonzalez. You're also subject to a mandatory period of post-release control, which means upon your release from prison, the adult parole authority may will supervise you for not less than 1 year nor more than 3 years. If you violate that supervision, you can be returned to prison for up to 1/2 of the court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. Ms. Tranter, is there anything?
Judge, I just want to double check, you want an aggregate 36?
It's an aggregate, it's what has to be 24 plus, yeah.
Yeah,
It's an
okay,
aggregate.
I just want to double check.
The other thing that I want to mention to you, Mr. Brinson, I would not be opposed, if you're sincere today, is to at least consider judicial release at some period of time after you've been placed into the institution. I want to give you a chance, but you don't seem to be taking this seriously.
I do, sir. It was just rough.
You had an opportunity to speak. Now it's my turn. Yeah, I understand that. You know, the probation officer, and again, I'm just looking at the notes here. You cut off your monitor in January of 2025, and then you weren't arrested until, when was he arrested?
I believe he was booked into Warren County Jail on 11/21.
So for 10 months, you did nothing. You haven't completed any of my orders that I can see. So again, if you're having difficulty, then you reach out for help. You don't just make it worse by cutting off your monitor. That's the absolute worst thing you can do. So, but again, I will at least consider judicial release. You have to comply with the rules of the institution. Anything else, Mr. Wendell?
No, sir.
All right, that's all. Thank you.